36.
I apologize, Judge, yes.
21 CF 2886.
Yes, Your Honor. We have a reinstatement agreement. I don't think we have to have a score sheet on him. I don't think he scores, so DOC anyway. But it is a reinstatement.
It should not be a downward.
It's a reinstatement and modification to add a little bit of community service. May I approach?
You don't need a score sheet.
Everybody sign, Judge.
Thank you.
Thank you.
We don't need a score sheet.
Yes,
Would
ma'am.
you announce the plea?
Yes, Your Honor. In 21 CF 2886, Mr. Angel, English pronunciation Angel Benitez, would resolve the case with the felony VOP for reinstatement of probation and modification to add 24 hours community service. He's admitting the VOP. He will complete his existing obligations. He will pay a $100 VOP fee and a $150 public defender fee.
Your Honor, that was the state's agreement.
Very good. Mr. Benitez, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of your plea agreement,
Yes, sir.
and I see those same terms are contained in the written plea agreement that you've signed.
Yes, sir.
Have you reviewed this closely? Make sure you had all your legal questions answered. Yes?
Yes, sir.
And do you understand that by entering this plea agreement, you're waiving the right to go to a trial and you're waiving some other valuable rights in order to get a final resolution of this VOP?
Yes, sir.
Okay. Do you have any further questions regarding this?
sir.
Okay. Based upon that testimony, the court will reinstate probation and modify the probation to add 24 hours community service. The defendant will be admitting the VOP and will complete all existing obligations. In addition, there's the $100 VOP fee and the $150 public defender fee as well. Okay?
Yes, sir.
Any questions?
No, sir.
Thank you.
Judge,
Yes, sir.
I'm deeply sorry. He was not previously adjudicated guilty, and I have an error on that. I'm asking that he be allowed to maintain his withhold.
Your Honor, it's a modification. The state would offer that.
I apologize.
It's all right. No, it's all right.
Thank you.
It's important to get that
Super
detail.
important. You don't want to become a convicted felon, okay? And the state,
And Your Honor, that was also on the state's offer sheet.
and I apologize.
The state
for-
is
we
not
were-
going to change what's on its offer sheet.
That's right. I'm just glad we're talking.
Thank you. Yeah,
Very good.
thank you.
So Mr. Benitez, just for the record, so you'll hear the court say it, when you reinstate, there will be a withhold. We'll continue with your withhold. You'll not be adjudicated guilty
Okay.
of the felony. Okay?
Okay, sir.
Thank you.
Thank you. Yeah. You need to see it. Next, Your Honor, is Fiona Bess.
Okay?
I do not know what's wrong with my docket, Judge, but I just can't find things today.
It's 37 and 23 CF 1231.
Thank you. Your Honor, I'm approaching with an agreement that Ms. Bess has entered. It is for revoke and terminate, so I will need a score sheet, but she does not score prison. Let me.
I'll get to.
I probably have it. May I have your indulgence, Your Honor, for just a second? I think I have it. Yes, it's a 19.7 score. May I approach, Your Honor?
You may.
Excuse me. Oh, Steve, hold on. I don't think that has the VOP.
I'm sorry, Your Honor. Ms. Sharpless was asking whether it had the VOP on it.
I think that's the old score sheet.
It's going to have to be modified, that's correct. It will have to be modified, Judge. I'm sorry to
Okay, I can do that really quickly, Judge. I apologize for this.
Can I approach the back of the agreement?
Sure.
While she's working on that, we'll
Okay,
announce the terms.
very good.
Thank you.
This isn't the signed one.
Your Honor, under the terms of this violation of probation agreement in 23 CF 1231, Fiona Bess is admitting the VOP. She was previously adjudicated guilty. Revoke and terminate probation, credit for time served, $100 VOP fee, $150 public defender fees. She would have 6 months to pay the monetary obligations prior to going to collections.
Ms. Best, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Your score is 25.7, way off. More than 44 points. You're not scoring prison. Yes, sir. May I approach the attorney?
And you okay with the?
Yes, sir.
Score sheet? Okay. So, Ms. Best, you heard your attorney state the terms of your plea agreement, and I see those same terms are contained on the written plea agreement.
Yes, sir.
Have you read this agreement closely?
Yes, sir.
And you gone over it with your attorney, make sure you had all your legal questions answered, and make sure you understand it well?
Yes, sir.
Okay. And you understand that by entering this agreement, you're waiving some valuable legal rights, the right to go to a trial. I understand it's a pretty straightforward and advantageous agreement. I certainly understand why you would accept it, but I just want to make sure you're clear, you've gone over it, and you're comfortable this is in your best interest?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There'll be an admission of the VOPs, and you were previously adjudicated guilty, so this won't change that. We'll revoke and terminate probation. You will get credit for all time served. That'll actually be your sentence as credit for time served, so you don't have to have any additional time. And then you've got the fees and costs that you'll have 6 months to pay before they go to collection. That's important. Try and pay those during that 6 month period, so they'll go after your driver's license if you don't pay them.
Yes, sir.
Okay, any questions?
No, sir.
Okay, good luck.
Thank you, Your Honor. Next will be Leah Jasna Danielle Perillas. Ms. Perillas is number 41 on the docket, recalling her with an agreement that's been signed by all parties. Your Honor, this is a plea to the bench agreement on a VOP, so the score sheet will be provided as part of the sentencing hearing that will be set, and she does score under the guidelines 15 months, and that will be the cap. Of course, it's a VOP situation, and she's going to be asking for treatment, and she's a single mother. We're going to be asking for a pre-sentence report. She has no priors. May I approach?
You may.
And I'll announce the agreement, Your Honor. Under the terms of the violation of probation plea agreement in 21 CF 1074, Leah Perillas will be admitting the VOP with a 15-month DOC cap on DOC with credit for all time served and with no cap on supervision. The adjudication of guilt issue would be left to the discretion of the court. She got a withhold of adjudication originally. There will be a pre-sentence report ordered. I do want to note for the record, she had a private lawyer when her case was originally pled out, and I noted that the score sheet back then correctly showed what she pled out to was a second-degree felony, but I noted for the state and for her that I observed that the private lawyer, I assume it was he who wrote up the plea agreement, had it as a 5-year, 5,000 max, would have been of a third degree, but actually it was clearly indicated on the score sheet, and it was in fact a second-degree felony. I don't think it changes her desire to resolve this issue, but I just noted for the record, I brought it to everyone's attention. I think that's it, Your Honor.
The stated agreement.
Yes, Your Honor, state's agreement.
Ms. Barillas, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes,
Okay, so you heard your attorney state the terms of the plea agreement.
correct.
So you're admitting to the BOP, and there'll be a cap on any sentence, but you're pleading to the bench. In other words, you're basically pleading to the first part of the equation, but not everything but the sentencing. Actually, everything but the sentencing and the adjudication of guilt. That'll be done at sentencing, Mr. Medina, is that what you?
Yes, Your Honor, I'm asking for sentencing.
Sure.
We'll schedule that with Your Honor's judicial assistant. It'll
Right.
need to be far enough out to allow the pre-sentence report.
What I'm saying is that the discretion will be exercised, the adjudication of guilt will be addressed at the sentencing, correct?
Yes, Your Honor.
Okay. That's what I anticipated, but I just wanted to make sure everybody was on the same page. So, and you will get credit for all time served. It does allow for no cap on supervision, so you could have some, you could have some or no DOC sentence, but some or a longer probationary period. Do you understand all that?
Could you repeat the DOC part that you said?
So there's two components to this.
Okay,
One is if there is an incarcerative sentence, in other words, a DOC,
okay,
or
okay,
probation.
right,
Those are two elements. I will have the discretion on the incarceration to do up to 15 months.
Okay.
Can't do more, I can do less, I can do none, okay?
understood.
But I also, no matter what I do over here, I can do some probation.
Okay,
I don't have to, might not do it, may do a little incarceration, may do nothing,
right,
okay?
I understand.
But the probation, there's no cap on that. Actually, there is a cap, it would be the 15 years that's on the underlying charge, right? But highly unlikely you would have probation that long period of time. But it could be, you could get some incarceration and some, relatively lengthy period of probation. I don't know.
Okay.
That's what we're gonna have to go. They're gonna do a pre-sentencing investigation. They're gonna give me a lot of information. And then, importantly, your attorney, you, through your attorney, will have the ability to argue whatever you want. This is why you should, in the state, of course, they're going to be probably arguing for the max. They generally do, and so.
Your Honor,
Thank you for explaining, I understand now, thank you.
she has a 10-year-old son, so her preference is going to be, and she's going to be asking for reinstatement, a modification.
I do understand that.
With outpatient, but I've also given her my investigator's contact information so that she could pursue a couple of different facilities in case for inpatient options, and hopefully we'll get those options lined up. One or more.
In order to sentence, have an incarcerative sentence below the 15 months, there would have to be a downward departure based on statutory factors, correct?
I think that with the reinstatement and modification, that the court could order some jail, but if she was going to prison, she would be adjudicated guilty, and that would be with a revocation, and that would, in that case, require a downward departure. However, I do note that with respect to a chronic substance abuser, there is a statute with people.
You do have, you have some possibilities of a
Right.
downward departure. I'm not excluding that.
Right.
I just want to make sure we're all clear and that that's been gone over with your client. It's kind of complicated technical sentencing issues.
Well, I didn't go into the details. May I just have a moment?
Sure.
I certainly explained the basic options, but in terms of the downward departure part of it, Your Honor, I have to explain.
The main thing what we're doing here today is, we don't want you to, agree to this. When we go to sentencing, you go, well, I didn't realize that was a possibility. I just want to make sure everybody's got the cards on the table.
Thank you, guys.
We're not trying to hide anything or trick you, okay? So, feel like you got a good understanding of what this agreement is, this plea to the bench?
Yes, I have a better understanding now. Thank you.
And you understand that you're waiving the right, you're obviously going to be able to argue at the sentencing, but other than the sentencing, this first part, the plea, that'll be a final resolution of that part of the case. Do you understand that?
Yes.
And you're waiving the right to go to a trial and all that. Do you understand that?
Yes.
And you believe that's in your best interest?
Yes.
Okay. Based on that testimony, the court will accept your plea. The defendant admits that it's BOP, and it'll be a plea to the bench. The defendant is receiving a 15-month DOC cap at sentencing with credit for all time served, and there's no cap on the supervision. And there's discretion of the court whether to withhold or to adjudicate. Okay?
Thank you.
Thank you very much.
Paper.
And that's for me. So,
Get in touch with my office as soon as possible. Hearings, schedule some times.
Who on the state is handling Robert Brazil?
That's my case, Your Honor.
Have you had any communication? I'm just wondering whether something might have been resolved, because I've got it being on this docket here with Mr. Howell. Is that yours?
yes, it is mine on a new law.
He was here this
He was
morning.
here. I would just ask to have the public defender appointed on Robert Brazil's VOP case too. He tried to talk to me.
The VOP case, is that 20, I've got it on the docket, 21 CF.
Right, that's the one that's on the docket
It's got
today.
John Howell being the attorney.
He
That
was
was
the
an
original.
attorney on the underlying
That's
case.
wrong.
He was on the underlying, it should be PD appointment on the VOP. He tried to talk to me about it. When I looked for him, he had gone ahead and.
So-
I thought he had already entered a denial, and we set him.
So enter a denial and we'll come back on March 14th.
Yes, sir.
Very good.
He'll be talking to me anyway.
What's our next case?
We can call John Chapman out. We have a stipulated order for an ROR that we've reached terms for the court's consideration.
Okay, that's right.
You don't know when next court date yet? To be determined.
Okay.
Okay?
All right, I just want to.
Sentencing will be set by the judge's judicial assistant based on the court's calendar. So right now, you don't have an next court date. Just stay in touch with Karen, set an appointment tomorrow, so we can talk.
All right, I will, sure, thanks.
Your Honor, we have discussed these terms. May I approach, Your Honor?
You may.
And I won't announce them unless the court wants me to.
Okay, very good.
And Your Honor, the state's reviewed them and would agree with those stipulations if the court was inclined to let Mr. Chapman out of jail. It's at the court's discretion.
The court has reviewed the stipulated order for an ROR bond with certain conditions, and the court approves and is executing the order.
Thank you, Your Honor. Okay.
Thank you, Your Honor.
Thank you, Mr. Chapman.
Judge, please, Mr. Chapman,
Sorry. Mr. Medina, we need another court date.
Yes, I would expect that it would be best to have him on that March
14th?
miscellaneous like we did with the other individual.
Continue to March 14th.
Thank you.
Thank you, Your Honor. Thank you.
It's miscellaneous is a good day when we're keeping track of a special situation. We want to make sure, I think it's worth it.
What's our next case, Mr. Burnett?
I think we're just calling in custody, ready for a few quick continuances. We're going to go with Bowden last.
Yes.
But the
What
others-
about Dykes? Did we do Dykes? We didn't do Dykes.
That will be very quick, Your Honor. I didn't even know he was on the docket, but I should. No, we need to do Dykes.
Yes.
I saw him 2 days ago, and it's all been a blur, Judge.
You think it's been a blur for you? And multiply the cases, but a blur for me. We have 500 cases this week.
Yes, Your Honor.
I know you all work them a lot harder, each individual case than I have to, unfortunately.
I'm making no excuses for myself, Your Honor. Not that it would do any good. So I think we're going to do Ashby, Dorsey, Dykes, McCoy, and then do Bowden last. Those are the ones that I have. Alphabetical, unless they're in the queue different. Doesn't matter to me. Oh, we got Dykes first. That's fine. Your Honor, Steve Medina with Nerion M. Dykes, 22 CF 29. When I met with Mr. Dykes day before last at Okaloosa County Jail to go over his desire to have the youthful offender designation removed, he informed me that he had retained Larissa Dudley, attorney, to represent him, and that she had requested to continue the status conference. I would ask that it be continued till March 14, so that Ms. Dudley can enter an appearance and meet with him and decide what they want to do.
Very good. The court will continue this matter till March 14th at 9 a.m. So you can meet with Ms. Dudley.
Appreciate it.
Thank you.
Ashby.
Your Honor, Eric D. Ashby is before the court on a bond motion, and I'm ready to proceed. I don't think it's going to take very long.
Very good. You may proceed.
Your Honor, Eric D. Ashby is before the court in 24 CF 101, and basically I've discussed with him if the court is willing to make a change, a bond reduction. His preference would be a signature bond. He does say that he has around $1,000, which would be correlating with a $10,000 cash or professional. He also said if that wasn't satisfactory, that he had a cousin who could perhaps loan him $1,000. So we're hoping somewhere between a signature and a $20,000 cash or professional would be his approach. He is ready to testify, Your Honor, about some of the background facts relating to the motion. May I have him sworn, Your Honor?
Yes, sir. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Would you state your full name, sir?
Eric Donovan Ashby.
Okay. And how long have you lived in the Fort Walton Beach area?
About 20 years.
Okay. We have 13 years in the motion, but it's probably more than 13.
Yes, Your Honor.
Okay. And where do you reside?
8 on Lark Street.
831?
831, yeah. 831 Lark Street.
Is that Fort Walton Beach?
Yes.
And how long have you lived there?
About 3 years.
Okay. And are you employed?
Yes, Your Honor.
What is your job? What do you do for a living?
I grind stumps. I own a stump, meaning the bank owns a stump grinder and some equipment.
And how
a trailer.
long have you been in that business?
I've been doing tree work for quite some time, but I've just started venturing out on my own for about 2 or 3 years.
Have you, did you turn yourself in on a failure to appear?
Yes, I did. I got the days mixed up.
Okay. Okay. Do you have anything else more you want the court to consider? For instance, is the existing $150,000 cash or professional bond something that you could have any hope to pay?
150 is
There's no,
far out of my league.
is what?
150,000 is far out of my league.
And I made some statements to the court about what your possibilities might be, up to maybe 20,000 with it correlating with 2,000 putting up for bond. Is that about the most you could come up with?
I mean, I could ask my dad, you know,
Okay.
maybe for another 500.
Is there anything else you would like the court to consider without talking about the facts of your case about bond? I think you, by the way, you told me you had a relative, actually a close, Vicky Fortune. Tell the court, will you, about Vicky Fortune and what you do for her?
That's the lady I live with. She has recently had a stroke. I haven't been in contact with her since I've been inside, but I believe she's still all right.
And do you take care of her?
Yes, I do. I make sure she's got food whenever she's hungry. She doesn't know when she's hungry. She just thinks she has stomachache.
How old is she? Is she elderly?
Yeah, she is. She had a stroke and
Okay.
she wasn't. Yeah, she's an elderly. Definitely an elderly.
Okay.
She is
Vicky
60,
Fortune?
60,
Okay.
69. She's almost 70.
Okay. Is there anything else you wanted the court to hear?
I also have my own health problems. My legs.
What are those problems?
I don't really know. I got to go to the doctor and find out what they're like that.
Okay. Is it circulation issues?
I'm not sure. I'm hoping.
Okay. Nothing further, Your Honor.
Who's handling this for the state?
This is my case, Your Honor. Your Honor, the state would object to that far of a reduction in the bond. I do believe that the bond as set is appropriate for this trafficking charge. The Okaloosa County Sheriff's Office has alleged that he was trafficking in methamphetamine. The weight of that methamphetamine appeared to be 21 grams. Your Honor, this is a minimum mandatory charge. He does have at least one prior possession of a controlled substance. He does have a couple of DUIs, Your Honor, so the state does believe that the high cash or professional bond is appropriate in this case.
May I clarify one thing, Your Honor?
You may.
Because in my questioning of him, I probably confused something, but you don't have any FTAs in this case. That was in another case that before you had an FTA where you were confused about your court dates?
FDA was in failure to appear.
What?
Failure to appear?
Was it in another case or was it in this case?
No, it was in another.
Okay, that's what I wanted to clarify. Thank you, Your Honor.
The court will reduce the bond, but not as much as the defendant wishes. The court will reduce it to $75,000.
Thank you, Your Honor.
Your Honor, you sit on this afternoon's docket as well?
Your Honor, he will go ahead and waive arraignment and plead not guilty. If an information has been filed, I do not have one in my file.
It has been filed.
It has been? Okay. Court will enter, accept a not guilty plea.
Okay. And Your Honor,
What's the case number on that?
It's 24 CF 101, Your Honor.
and Your Honor, he probably needs to be moved to the April 10. He was on April 8th.
Very good.
So your next court date will be
Continue until
April
April
10th.
10th.
All right, make an appointment if you get out. Thank you.
Next will be Mr. Dorsey. Yes. Dorsey.
We'll bring him this afternoon. Your Honor, Steve Medina with William B. Dorsey, 23 CF 1458. I just talked to Ms. Sharpless about this. If we can hold him over to the afternoon, 1:30, we think we'll be able to resolve his case without the court deciding the motion based on an agreement for to be hammered out, Your Honor. But it's what we discussed.
Give me the name again.
Dorsey.
Dorsey.
Your Honor, it's William Brian Dorsey, 23 CF 1458.
So you want to hold over till the afternoon?
Just hold over the afternoon. Ms. Sharpless informed me that we can reach a deal.
Okay, very good.
Thank you.
Thank you.
Thank you.
Wait, Mr. Dorsey. Frank, we're gonna hold Mr. Dorsey until 1:30.
McCoy.
Your Honor, Steve Medina with, how do you pronounce your first name, Mr. McCoy?
Jara.
Jar M. McCoy. Mr. McCoy, I'm sorry, I do not know the docket number.
41.
Thank you. He's before the court in 19 CF 2428, 19 CF 2627, 19 CF 2628, 19 CF 2629, and 19 CF 2638. Basically, Your Honor, he's here on a VOP. He would love to resolve it today, but I do need the state's offer. He did serve Louisiana prison sentence in relation to the basis for the VOP, is my understanding. He's going to be seeking, if it's possible, some sort of a deal that either gave him time served, taking into account the prison that he did, with a revoke and terminate, or if possible, reinstatement. I'm not anticipating we can work it out today, but we'd love to if we could. Could we get the state's recommendation?
Your Honor, the state's going to be seeking prison in this case. I'll get the score sheet of the Mr. Medina. He should already have it, but I'll check on
Your
that. So
Honor.
it's going to be a DOC recommendation.
Your Honor, if we could continue to enter a denial and without subpoenas, put it on the next VOP.
The court will enter a denial, we'll come back, continue it until 3/14.
March 14th. Okay, come see. Thank you. Thank you, Your Honor.
Medina, did we ever finish Benning?
We did not finish Benning. If she's in the queue, I don't know if we have any information. We didn't hear back from Mr. Barnes.
I'm not, but if we hold her to the afternoon, we might be able to work. I hate doing that, but we might be able to.
If we can hold her till 1:30, we may have a better, more productive time. Thank you.
Probably do the same thing we just did with Mr. Chapman.
And I've got Mr. Bowden ready.
Yeah, let's go with Mr. Bowden, and we'll handle Ms. Benning this afternoon, possibly with a
Yes, sir.
stipulated order.
You know, looking at time, and I know we have pretrial detentions at 12:30, are we just gonna roll right into that, or is the court gonna take a break?
I'm planning on rolling right into it. I apologize.
It's all right, Donor, my anticipation is probably about 2 minutes on that.
What's that?
Likely continuance, in my understanding.
I think it's going to be.
I'm sorry, say that again.
After speaking with State, it's likely gonna be continuance on the pretrial detention hearing, so it won't take long either.
Okay, gotcha.
Your Honor, Steve Medina with Davin O. Bowden,
Here you go.
23 CF 1998.
Okay. Good afternoon, Mr. Bowden. We were here yesterday, and what did you get the case number?
I'm sorry, Judge, it's 23 CF 1998.
Okay. So yesterday, we dealt with the first order of business, and that was that the court found the defendant to be competent to proceed. That's what we were waiting for. In order to do anything, we couldn't take any action. And we're here today on both a Nelson and a Feretta hearing. The first thing with regards to the Nelson hearing, that's pretty simple. You have a right to dismiss your attorney. You're not obligated to have an attorney, okay? So, and it's my understanding, and that's where I need to, did I swear you in? Let me swear you in. Raise your right hand.
I don't raise my right hand.
What's that?
I affirm my religious practice.
Raise your right hand and listen to what I'm going to say, and then if you object, then we'll deal with it. Raise your right hand.
I don't raise my right hand. That's my religious practice.
Okay. When you want to go back to the court, if you want to come back, take them back. When you want to come out and address this court, I can't swear. Look,
I can practice my religion how I want to practice it. I don't raise my right hand.
Okay.
You can't force me to raise my right hand. It is my religious practice. I'm a Hebrew. That is my First Amendment right. I ain't never raised my right hand in damn courthouse that I've been in, and I ain't gonna do it now. And you ain't gonna force me to do it now. That is my religious practice.
Okay. So
I said I affirm.
You listen to me? Can you listen? Can I talk? Listen to what I'm saying. Do you swear or affirm? So I'm asking you whether you affirm. You have either or. You have the right to affirm. You swear or affirm that the information you're about to provide this court is the truth and nothing but the truth.
I said I affirm. This ain't my first time doing this.
So, as it relates to the Nelson hearing, as I said to you before, you don't have an obligation to keep an attorney. A Nelson hearing is generally a hearing if you wish to have another attorney appointed, another public defender often. In this case, it's my understanding that you're not seeking to have another attorney appointed. You want to just represent yourself, correct?
That's what I want to do.
Okay. Is that correct?
That's what I want to do.
Okay. So, there's no need to conduct a Nelson hearing. So, as it relates to that, Mr. Medina, you're discharged.
Thank you, Your Honor.
Okay, so you're representing yourself, but before you go, Mr. Medina, I'm going to do what's called another hearing that I don't know if you've actually requested it, but it's
I did request it and would be happy to remain, Your Honor.
the Feretta hearing. So, are you intending to hire a private attorney or represent yourself?
I don't represent myself.
And you do understand that we have previously appointed, and you have a right to have an appointed attorney if you can't afford one. You understand that?
I understand that.
Okay. And it's my understanding that you don't want me to appoint you a public defender?
Nah.
Okay. So, what I need to do, what I'm obligated to do, is I need to ask you some questions to make sure you understand the effect of not having an attorney, okay? So, first question, I'm going to explain some of the ways that having a lawyer can be an advantage, okay? And I'm required to ask you this because when all this is said and done, if it doesn't turn out well for you, if it doesn't, don't know how well, you may prevail on all counts. We don't want you to come back and say, if I'd have had an attorney, you wouldn't have done this to me. Okay, so I want to make sure you're clear, that you understand the effect of not having an attorney. Okay, that's the purpose of my questions. I want to explain some of the advantages. So, actually, what this does is it encourages you to basically accept an attorney. That's the bottom line. I want to be clear about it. Normally, a lawyer's legal knowledge and expertise can affect bail issues, pretrial issues, etc. Do you understand that?
I understand.
And At trial, maybe you have a great deal of trial experience, I don't know. But the attorney will be able to argue for your side during the entire trial and make sure and make the best legal arguments for your defense. Do you understand that?
Yeah, I do.
And since the whole jury selection, that's a very significant, there are a number of legal procedures that are involved with the jury selection. The lawyer's knowledge of the legal procedures could assist you on the selection process, because that's going to be a very important part of the trial that at this point is we're heading towards. Do you understand all that?
Right, right.
And the lawyer obviously has the ability to call witnesses, question witnesses, and to present evidence. Those are all very technical matters. Are you familiar with the rules of criminal procedure?
Pretty much I am.
Okay.
Yeah.
And
Very familiar
you're
with it.
aware of the rules of evidence?
Yeah, pretty much Brady.
Okay.
You know,
Okay.
320,
Brady? Okay.
220, yeah.
That's one. Okay. What is Brady?
Brady is the evidence that the state has to give me, that they're responsible for all the stuff that's in the police possession and all that stuff. They're like, yeah, if you really like to check my record from Washington County, Bay County, to Brevard County, you can see that.
Okay.
Yeah, I'm not.
So, that's good. So you're aware of the rules of evidence and know about them?
Yeah, I do.
You know how to preserve error in a trial for
Yeah, I
a
do.
possible appeal? You know about that?
I know about that too.
Okay. And if you would be convicted, are you familiar with the post-trial rules on possible appeals or things of that sort?
Right.
You're aware of all that?
Yeah.
Okay. So, I'm going to just ask you a few more questions, then we'll proceed from today. Do you understand that you're not going to? One of the challenges of being a judge with somebody who's operating pro se, and with all due respect, unless you're a trained lawyer, you're probably not going to understand some of the things I asked you about as well as a lawyer. One of the challenges is that I'm not allowed to assist a pro se, just like I'm not allowed to assist a lawyer.
I understand that.
That's taking sides. I don't take sides, okay?
Right.
But you're not going to get any special treatment from the court because you're representing yourself. Do you understand that?
Yeah, I do.
Okay. And you understand that you're not going to be entitled to a continuance simply because you represent yourself?
Right.
Okay. And you also actually will be limited to the legal resources that are available to you. You will not be entitled to any additional library privileges because you're representing yourself. Do you understand that?
Right.
The lawyer has many fewer restrictions in researching your defense. Do you understand that?
Right.
So, you are not required to possess the legal knowledge or the skills of an attorney in order to represent yourself. However, you will still be required to abide by the rules of criminal law and the rules of courtroom procedure. These laws took lawyers years to learn and abide by. If you demonstrate an unwillingness to abide by these rules, and these are the same rules everybody applies, then I will or could and may terminate your self-representation. Do you understand that?
Yes.
And do you understand that if you're disruptive in the courtroom, the court can also terminate your self-representation and remove you from the courtroom, in which case the trial would continue without your presence. Do you understand that?
Yes.
Okay. And do you understand that this is important, that your access to the state attorney who's prosecuting you will be severely reduced as compared to a lawyer who can easily contact the state attorney? Do you understand that? Yes?
Yes.
Okay. And in addition, The state will not go any easier on you or give you any special treatment because you're representing yourself.
Right.
The state will present its case against you as if you were an experienced lawyer.
Right.
And in this case, there is a stay-away order in place, isn't there?
From the victim?
Yes.
I believe so, Your Honor, as a condition of bond.
And because there is a stay-away order in effect, you will be prohibited from contacting the victim or other witnesses who are part of the stay-away order. Do you understand that?
Right.
But if you're represented by an attorney, your attorney is allowed to speak to these people and question them regarding your testimony. Do you understand that difference?
Yes, I do.
Okay. And finally, if you are convicted, you cannot claim an appeal that your lack of legal knowledge or skill constitutes a basis for a new trial. Okay? In other words, you can't claim you received ineffective counsel if you're representing yourself. Do you understand that?
Right.
So, me having said all those things, do you understand these dangers and disadvantages of representing yourself?
Yeah, I understand it all.
Do you have any questions about these dangers
None
and
of it.
disadvantages? No? No? I didn't hear you.
None.
None, okay.
No questions.
Very good. So have you received and read a copy of the charges against you?
Ever received any? No, I ain't received none of that. It's been 90 days. I ain't received no evidence of that. But yesterday you said that you was trying to protect my rights, right? But I ain't seen none of that happen either.
Okay. And what is the maximum jail term sentence on the charges?
Your Honor, this is a third-degree felony, so the maximum is 5 years.
Your Honor,
Yes.
my colleague just asked that the court may want to reaffirm on the record that the court finds Mr. Bowden is competent to proceed.
Well, I think that yesterday we made that ruling. If I didn't, I certainly, based upon the evaluations that were made, the court found that he was competent. I thought I did yesterday.
Yes, Your Honor, it's just, I know we gotta, every time he's in court, we gotta do the Beretta each time, and so it's almost like, well, let's go and make sure we say, hey, after all that, I find that you're competent to represent yourself as well, just an abundance of caution.
So, so are you on any, are you taking any medication? No? Very good. Based upon the testimony of the defendant, court finds him competent to proceed and competent to represent himself. Okay. So, now, as I mentioned to you yesterday, you have filed numerous papers. And during all that time in which you were filing those, you were represented by counsel until today, when your counsel was dismissed. So everything has been filed before today. Under law, is a nullity. And it's not being, so I just want you to know, everything you filed, the court has reviewed, the court considered a nullity under the law and is not considered. So now we're proceeding, you're representing yourself, and we are proceeding with that. As the state will be providing discovery, et cetera.
Yes, Your Honor, I've never personally provided discovery to a pro se person, but obviously that is the state's obligation. I know that our office has done it, so I will get with Chief Weeks and Lieutenant McDaniels in my supervision and make sure that Mr. Bowden gets a copy of that at the jail. I do know that they do have the ability to look things up, and I think there are some computers and stuff they can use to review their discovery, because we just did that for another person who went to trial. So I just need to figure out what that system is for him to make sure he gets it.
So, I'm just, the reason why I'm saying that, if you need to file something, just understand this. You may not believe what I'm saying, don't care what you believe what I'm saying, but my job is not to take sides here, okay? That's not my job. I'll tell you straight up, I think it's to your disadvantage to operate pro se. I think you're making a huge mistake. It's going to hurt you, and it would much more likely lead to a conviction on your part than not have. That's just statistically, because you're not a trained lawyer.
That's what you feel like, right?
That's it. But hey, you're gonna have your rights. My job is to protect your rights, and I aim to do that.
If you was protecting my,
I aim to do that.
if you was protecting my rights, I'd have been 90 days ago. I'd have been had a Pharrell and Nelson here.
It's not how you think your rights are.
I'm just saying.
How you think.
I'm just saying. I'm not new to this.
Okay.
I'm not new to this.
So we will. The one thing I would say is you need to understand. Just because you file something doesn't mean you need the wheels of these cases, everybody's cases, move slowly. Okay? So just because something is filed doesn't mean there's immediate action on it. I'm just telling you.
I know how I go.
Okay.
You sitting trying to laugh and smile like I know how this go right here.
Okay, good.
But I'll be sending you a discovery of what I need, of what does
Demand for
exist.
discovery?
Yeah, I will. You will get the discovery of all that I need.
Okay. So we will, the next hearing that is April 10th, which is our next pre-trial. Hopefully there will be some discovery going back and forth, and you guys can kind of begin to see where things are going.
Yes, sir.
Okay? Do you have any questions?
No, I don't.
Thank you, sir. Okay. So that's our morning docket.
Your Honor, I don't have anything else in front of you today. May I be excused?
You may.
Thank you.
So, I think we have a pretrial detention.
Yes, Your Honor.
Correct. Ready?
Mr. Bryant.
Your Honor, can I also be excused from the courtroom?
You
The
may.
trial detention is Mr. Deans. Thank you.
Your Honor, this is going to be Mr. Bryant.
We will plan on starting, and we'll come back at 1:30. I know it's not much time.
Thank you, Judge.
Mr. Lasco, hold on. Defense counsel, let me ask this question. Do you all want to take a full hour over lunch or come back at 1:30? I can do either.
Your Honor,
I'm right down the hall. I'm just sitting at my desk.
I don't have anything else in front of you all day.
Oh, you don't? You don't have any of the arraignments?
No, Your Honor, I just checked.
Okay, well, you're good then, John.
Your Honor, I think we customarily defer to the courtroom security and clerk's office because we know they have needs too.
You want to take an hour off or just start at 1:30 and roll with it?
Judge, I only need like 5 minutes to eat, so whatever you.
I'm good at 1:30, Your Honor.
1:30. We'll just stay on our docket 1:30. We'll finish this up and then go, and of course, you're excused, you don't have to.
Your Honor, I think what might cause some confusion, I had a 2:30 with you, but the defense attorney withdrew, so the case fell off the docket.
Okay, very good.
Thank you, Judge.
Thank you. Mr. Gates, would you please announce the case?
I do get at least one right.
I guess it's two different probations, one probation.
Yeah, it says two different cases, two different violations, but you're on one concurrent probation.
Right.
Your Honor, this is Mr. Bryant before the court in 24 CF 353 for pretrial detention. I'll let this date go from there.
Your Honor, the state is requesting a continuance on the pretrial detention hearing. We have made multiple efforts to get in contact with the victim and to comply with Marcy's law. However, we have not received a response. We even sent an email as well as even voice messages. The state would like to also add that the defendant is currently on probation in two cases, 23 CF 1225 and I believe 24 CF 2457. And the 24 CF 2457 is a
Okay, say those two again.
23 CF 1225 and 24 CF 23 CF 2457.
2457.
Correct.
36 points.
Okay.
Plus the 12 for the
in-
violations.
You say he's on probation, these two?
Yes, Your Honor. He's on probation, and in the 2457 case, it's actually, he pled to a misdemeanor DV battery, which involves the same victim in the current new law violation case. So for that, since he's not entitled to bond on a VOP, the state is requesting that he be held on no bond on the violations of probation.
Yes, Your Honor, and it's my understanding he's already gone through first appearance on the bond, the VOPs, and there's already a no bond set. The court, I'm hoping the court knows my opinion on Marcy's law and whether it applies to pretrial detention. I've argued a few times that the way I see the statute, it does not apply. However, speaking of Mr. Bryant, given that he is already being held on a no bond, I don't think we're going to object to the continuance on the pretrial detention hearing. It would do us no good at this point anyway. Even if I was to make the best argument possible, the court felt a bond is appropriate, he's not going to go anywhere today either.
Yeah, you're right. So, and the state does have the right to one-time continuance on these
One-
pretrial detentions.
Yes, Your Honor, one day I'm
Pretty much a free pass on the first one. So we will, we'll go ahead and continue this until next Thursday.
Yes, Your Honor.
12:30.
Yes, Your Honor.
Thank you very much.
Thursday, 12:30. Steve, your file. If she's not telling us.
My file? You just did the pretrial. Oh.